Hey guys, some of you have been asking for an update on the Pineville debacle, and so here it is. I go to trial on June the 21st, which is next week in Pineville. I introduced a motion to dismiss based on a report from a legal expert out of Louisiana who he exposes bad cops. And that's really his specialty. He's retired. He teaches law enforcement certification classes and yada, yada, yada. And I thought you guys might like to hear his report, his case analysis. So I'm going to read it to you. As I said, I introduced a motion to dismiss based on this, and Pineville has declined to hear the motion until the actual court date. So I'm going to withdraw that motion, and we're going to go ahead and go to trial. I have subpoenaed the commanding general of Camp Beauregard, and I subpoenaed his boss. You know who his boss is, right? The governor of Louisiana. So we'll see how that all goes. But here is that report. I'm going to read it to you real quick. It's about 8 pages long, but I'll get through it pretty quickly. Case analysis. I was contacted via phone by Mr. Warden, who asked me to analyze his arrest on July 7th, 2017 by the Pineville City Police Department. I analyzed the arrest report, videos, and a statement from Mr. Warden. After analysis of all provided information, I formed the opinion Mr. Warden was subjected to Louisiana constitutional rights violations, United States constitutional rights violations, and the victim of state and federal crimes committed by persons acting under color of law. I based the formation of my opinions on the following information. Video analysis. I provided him my body cam footage. He was also provided the dash cam footage from the police cars. Initial contact by the military police. I'm just going to skim through this one really quick because there's not much here. It just says the MPs came in, did their job, and said that I wasn't doing anything wrong and went on about their business. Then we get to the next part, which is contact from Command Sergeant Major Rufus Jones. A white Chevrolet Impala with a logo and a spotlight arrived. White male, later identified as Command Sergeant Major CSM Rufus Jones, exited the vehicle and approached Mr. Warden. The white male was in civilian attire. He was not wearing a military uniform or a police uniform. He was not displaying a badge or a weapon. He placed his hands in his pockets and questioned Mr. Warden. The placing of hands in pockets when dealing with a person suspected of committing a crime is a serious officer safety issue. This indicated Command Sergeant Major Jones was not properly trained or perceived the person he was dealing with was not a threat. CSM Jones questioned Mr. Warden about his activities. CSM Jones informed Warden that he could not film without any legal justification. CSM Jones said Mr. Warden could not film a military installation and claimed he was standing on military installation property. CSM Jones threatened to arrest Mr. Warden if he stood in the road. CSM Jones did not identify himself as a law enforcement officer. This is an imperative requirement, especially given later claims Mr. Warden was charged with resisting an officer. CSM Jones asked Mr. Warden his last name, and Mr. Warden did not provide it. CSM Jones asked him if he had an ID, and Mr. Warden said he did not. CSM Jones informed Mr. Warden, "You are in the state of Louisiana. State of Louisiana requires ID on everybody." This was a false statement, and that there is no requirement for everyone in Louisiana to carry an ID. The statement indicates CSM Jones was not trained in Louisiana law. A written statement from CSM Jones later confirmed his ignorance of Louisiana law when he wrote, "You are in Louisiana. Louisiana requires everyone to identify themselves and have ID on them." Mr. Warden informed CSM Jones that the state of Louisiana required him to identify himself when lawfully detained. Illegal detention. Mr. Warden asked CSM Jones if he was detaining him, and CSM Jones responded that he was, while reaching and grabbing Mr. Warden's arms. CSM Jones had not identified himself as a law enforcement officer. He had not communicated any lawful reason for the detention. There were no articulable facts indicating Mr. Warden was committing a crime. The written statement provided by CSM Jones did not indicate why Mr. Warden did not indicate why Mr. Warden was detained. Therefore, there was no reasonable suspicion to lawfully detain Mr. Warden, and therefore a violation of his Fourth Amendment rights. The non-consensual contact with Mr. Warden is suspected to be a violation of Louisiana RS 14.35, simple battery. Furthermore, it could be a violation of Title 18, Section 242 of the U.S. Code. Mr. Warden asked what crime he was suspected of committing. CSM Jones responded that he did not know what he was doing. CSM Jones admitted he did not know. This was further confirmation CSM Jones did not have reasonable suspicion that a crime was committed, supporting either his ignorance of the law or purposefully making an unlawful detention. The detention was verbal and physical. Mr. Warden showed no evidence of physical resistance. CSM Jones told Warden during an apparent search he was taking everything from Mr. Warden and that he was looking for weapons, guns, knives, narcotics, or anything illegal because he was taking Mr. Warden onto his installation. The statement that he was taking Mr. Warden onto his installation indicated CSM Jones knew that Mr. Warden was not on the installation while he was performing the search. There was no evidence in the video or in CSM Jones's statement of articulable facts Mr. Warden was armed. Therefore, any pat-down was unconstitutional. This indicates CSM Jones is not a properly trained police officer. CSM Jones informed Mr. Warden he was detained. He did not inform him he was under arrest. The video indicated CSM Jones performed a search in addition to an illegal detention. A search requires probable cause. CSM Jones did not have so much as reasonable suspicion. Mr. Warden asked about what crime he was suspected of, and CSM Jones still did not have an answer. CSM Jones stated, "Well, we're going to find out what crime." He then said he was detaining him to find out what was going on. CSM Jones showed he was not aware of the requirement of reasonable suspicion of criminal activity as a minimum burden of proof to make lawful detention. Mr. Warden was detained, patted down, searched, cuffed, and placed in the back of a police vehicle by CSM Jones without legal justification. The combination of these actions turned the unlawful detention into an unlawful arrest by construct without probable cause. There was no reasonable suspicion of a crime to justify the detention. There was no reasonable suspicion he was armed to justify the pat-down. There was no probable cause to search. There was no probable cause to arrest. And then here we come to Pineville Police Department's arrival. Officer Evans approached Mr. Warden while he was seated in the vehicle and asked him his name. The officer informed him he was detained because he was on a military installation and he was told to leave. The video did not contain articulable facts supporting that Mr. Warden was asked to leave, nor that he was on military installation property was under control of military personnel without authorization to order someone to leave. The evidence supporting Evans' belief that Mr. Warden was lawfully detained was described in a written report that is discussed in the statement analysis section. Officer Evans was on the scene for a very brief period, approximately 15 seconds, which he spent walking from his patrol car to the back seat of CSM Jones's vehicle. Officer Evans then asked Mr. Warden his identifying information. Any articulable facts supporting lawful detention would have been based on information received prior to arriving at the scene. Therefore, the detention was not made by Officer Evans. It was made by CSM Jones. Officer Evans made no effort to determine if Mr. Warden was lawfully detained prior to informing Mr. Warden he was under arrest for resisting an officer. Therefore, Evans was acting on the authority of Jones. Mr. Warden was arrested prior to being informed of such by Officer Evans. Officer Evans asked for ID, which Mr. Warden did not provide. Mr. Warden provided his name, date of birth, and address. Mr. Warden then invoked his right to remain silent. Officer Evans asked him to repeat his date of birth, which Mr. Warden refused. Mr. Warden then reported there was a firearm laying on the front seat of the vehicle. If there was an unsecure firearm in the vehicle as indicated, and there was, CSM Jones should receive training in proper security of suspects in the interest of officer safety. Officer Evans stated, "I am letting you know right now you are under arrest. Did they advise you of that?" Officer Evans informed Warden he was under arrest for resisting an officer. The officer explained he was being arrested for not repeating his information. The only information Warden did not repeat when asked was his date of birth. The officer later documented in his report, Louisiana CCRP 215.1 requires him to give his date of birth. CCRP 215.1 does not require date of birth. It requires name and address. Resisting an officer also requires that the person who refuses to provide identifying information be lawfully detained. The detention and arrest which occurred prior to refusal to repeat the date of birth was not lawful. The arrest made in the direct presence of CSM Jones and appeared to be at his behest. Officer Evans then removed Mr. Warden from the backseat of the vehicle. CSM Jones then removed the body camera worn by Mr. Warden. Mr. Warden protested the seizure of his camera. CSM Jones' voice was captured on the camera stating he was taking the camera as evidence to review it to see what he was filming. CSM Jones did not state the legal manner in which he would search the camera. A search of the camera would have required valid consent or a search warrant. Statement analysis. I analyzed the statements of Sergeant Alan Durson, that's the MP, Command Sergeant Major Rufus Jones, Rufy, and Officer James Evans. Statement analysis, I'm just going to skip Sergeant Durson's because there's nothing really there. CSM Jones. CSM Jones reported he received a phone call of a white male filming the entry gate. The white male was filming a documentary for the U.S. Marshals. I never said that. He was advised the subject was told to leave but refused. Never happened. There was no evidence documented in the video or other reports indicating Mr. Warden was told to leave. Either someone lied to CSM Jones or the written statement was inaccurate. CSM Jones did not report who made the call. He did not report what number the call came from. He did not report what phone he received the call on. The details on the phone call are seriously lacking in sufficient detail required in an official police report. In this particular case, the reported phone call is not consistent with other written reports and the video evidence. CSM Jones then describes the actions of a lawful, voluntary contact by engaging in conversation with Mr. Warden. CSM Jones reported Mr. Warden was argumentative. While perceptual, the video evidence did not support Mr. Warden was argumentative. Mr. Warden was calm and conversational, while CSM Jones appeared standoffish. CSM Jones stated, "You are filming the entry gate of a military facility which is not authorized." He further suggested he was concerned that he was filming. CSM Jones did not report the actions as illegal. He reported that he was concerned and that it was unauthorized. He reported he wanted to know why he was filming and what he might do with the video. CSM Jones reported Mr. Warden lied to officers about what he was doing. The video evidence directly contradicts Mr. Warden lied about what he was doing. The statement Mr. Warden lied is false, excluding the sarcastic remark he parachuted in. CSM Jones reported he did not know if Mr. Warden was pre-planning for a terrorist attack. The video and written reports offered no articulable facts Mr. Warden was planning a terrorist attack. CSM Jones wrote, "I then advised him, you are in Louisiana. Louisiana requires everyone to identify themselves and have ID on them." CSM Jones is apparently not familiar with Louisiana law as it pertains to the possession of ID. This indicated CSM Jones was not properly trained, or he ignored his training and was making up laws that did not exist. Which do you guys find to be typical? CSM Jones reported he told Mr. Warden he was detained and walked behind him and placed him in handcuffs. The report did not indicate CSM Jones checked the cuffs for tightness, double locked them, etc. It was not clear in the video if they were checked for tightness or double locked. This is further evidence of lack of proper training. I'll tell you guys, the standard for checking the tightness of handcuffs is, can you get your finger in between the cuff and the skin? When I'm cuffed, I can actually check the tightness, and if it's not appropriately fastened, I generally will let them know. I do not recall if I checked that in this instance or not. CSM Jones described Warden as becoming irate. While this is perceptual, Warden did not appear irate. CSM Jones' description of irate behavior indicates a lack of experience with truly irate persons commonly encountered by law enforcement officers. Jones answered Warden's question about why he was detained. Jones wrote, "I don't know yet. You won't talk to me. You won't cooperate or give me an ID." This statement further supports Jones had no justification for a detention and is unaware that a police officer must have reasonable suspicion to detain. Jones reported he took Warden's camera so he could cuff him. Jones did not document he checked the cuffs for tightness, double locked them. Jones did not document any reason for cuffing Warden. Jones wrote that he was taking his cameras and stuff to figure out what he was doing and who he was. Jones appears unaware that police are not allowed to detain, cuff, pat down, search, seize property, and arrest persons to see what they are doing. Jones wrote he patted Warden down for officer safety. Jones provided no articulable facts supporting Warden was armed. Jones appeared unaware that an officer must have and document facts supporting a person is armed, reasonable suspicion, before conducting a pat-down for weapons such as a bulge under clothing that might be a weapon. Further, any pat-down must be made after a lawful detention. Jones lacked reasonable suspicion of a crime was committed and reasonable suspicion he was armed. Jones contradicted himself in the report on whether he conducted a pat-down or a search. He described it as a pat-down of outer clothing, but he said he was looking for anything illegal, making it a search, not a pat-down for weapons. Jones said he removed the camera for security reasons, but he did not describe what those reasons were. I will tell you, Jones was going into my pockets. In the video, you'll hear me object to that and tell him that a pat-down does not allow that. Jones admitted he was the one who was detaining Warden, therefore supporting other officers at the scene were acting on authority of Jones, not independent information. Jones further wrote he was asked by Pineville Officer Evans, "Do you want me to arrest him?" And Jones responded, "That's fine. I will just go with you to Pineville PD to figure out who he is." Warden was arrested based on the order of Jones. Jones knew or should have known he did not have legal authority to detain, pat down, search, or arrest Warden. Jones reported he detained Warden to find out who he was and why he was videotaping. This is further evidence Jones is unaware of required burdens of proof required for lawful detentions. Jones is not allowed to detain people who are suspected of a crime, who are not suspected of a crime, nor can he detain them to see what they are doing. Jones wrote that he considered Warden a terrorist until he found out anything further. This is first attempt by Jones to explain criminal activity, i.e. terrorism. All CSM Jones needed was to provide articulable facts that would lead a reasonable officer to believe Warden might be a terrorist. Jones did not provide objectionable facts to support Warden was a terrorist. To alleviate his concern, Jones described he was considered a terrorist because he would not tell him why he was there. Jones explained that when someone does not identify themselves and will not tell him why they are there, I have no other choice but to hold you until I found out further. This mentality means Jones may detain and incarcerate anyone of which he does not have knowledge of their intentions and is unwilling to explain themselves. Jones stated, until I check you out and see what is on your video cameras, you may be pending other charges, and I will not be releasing your cameras to you. Jones basically threatened to keep the property of Warden until he could search it. Jones did not articulate any facts that would support seizure or probable cause to search electronic devices. Jones appears unaware that he cannot seize and search property without a warrant, which must be supported by probable cause. Jones did not document any articulable facts that support probable cause. There was evidence of a crime. That evidence might be found on the camera that was searched. Jones then described he got consent from Warden to search the cameras. Jones is apparently unaware consent must be voluntary and not under threat of holding him and his property. The fact that Jones wrote these things down is simply amazing. It shows the lack of understanding of basic law enforcement training and constitutional limitations. It appears he may believe his actions are justifiable. I'll just skip over to the conclusion because this video is getting a little long. CSM Jones was challenged by a constitutional auditor. Such auditors place themselves in situations where they are likely to be encountered by government officials. The officials are essentially tested on their ability to act within the limits of the law. CSM Jones did not act within the limits of Louisiana and U.S. constitutional protections afforded to persons within the United States and the state of Louisiana. Mr. Warden was subjected to unlawful detention, pat-down, search, and arrest. That's it. Guys, you'll be seeing some videos from Pineville later this week as the things develop in court. Until then, I have a couple other things that I'm working on, and I will see you again soon. Y'all be safe.